Mother and petitioner to the single justice. Mother contends that the single justice erred in denying her relief in the form of ordering a 72-hour hearing. The court, ex parte, ordered a removal and then refused to allow Mother a 72-hour hearing.
Ms. Hanley, what is still open in the trial court? What proceedings, if any, are still open?
There are no proceedings. The matter was dismissed in the trial court in September.
And what is the case with respect to any criminal proceedings against your client or the father?
The matter was null prost recently.
So, needless to say, the word moot might come to mind.
Yes, but the problem would be is that Mother still remains in Russia with her 3 children, and she would like to return to the United States. But since there's nothing, I'm not clear what the relationship of her return and this case is at the moment. Well, she's very confident that if she does return, that the department will reopen its case, that the district attorney will again seek to prosecute on those same charges.
And that's based on what? You know, is her confidence that that will happen, is there something?
Well, it seems to be clear from the court's record that the court would not proceed. At the February 1 hearing, the court stated over 20 times that the court wanted the children there and that the matter would not proceed because the children were not there. So I think that once the children are in the jurisdiction again, that not only the department but the court would act on removing custody.
The court has no proceeding.
It would be a new proceeding, correct? So
it would be a new proceeding.
they'd have to start all over again.
Yes.
And the court couldn't start it itself.
Well, anyone can file a care and protection petition. It doesn't need to be the Department of Social Services. And there were a large number of people involved in this matter, so it's highly likely that another care and protection would be filed when this care and protection was only dismissed because the children weren't available.
So what is so particular or important systemically about this case that we should decide it, even though it is clearly moot?
Well, the issue that the critical point is that the department went in ex parte and sought a removal of the children and yet opposed any further opportunity for the parents, cut off any further opportunity for Mother to prove to the court that the evidence was not sufficient, that ex parte hearing evidence was not sufficient.
But I thought the mother took the children out of the state.
And the country.
In the country.
The mother took the children out of the state before the care and protection had been even filed. And that's what paved the way to the criminal kidnapping charges. Mother left the state on January 16th and traveled to New York to meet with her in-laws, who was a physician and wanted to consult with him.
And at the time that she left, was she aware that there was an abuse investigation going on?
She was aware that the department was involved, but the department had left her children with her on the condition that the father remained out of the home, and they had abided by those conditions. And once the department was notified that the mother and the children were out of state, it was on that notification that the department went in and filed a care and protection, which paved the way for the criminal kidnapping charges.
But in the week beforehand, my understanding is that there were interactions between both parents and the department. There was a sane interview scheduled. The father left the house.
The father left the home immediately when the DSS workers were in the home. He left immediately. He signed a contract saying that he would be out of the home. It wasn't, and Saturday morning, the mother thought it was prudent that the child be examined in light of the allegations, despite the fact that the department had never offered or asked that happen. Saturday morning, she brought the child to the pediatrician. Monday morning was when she decided to travel to New York.
And she didn't return the children to Massachusetts, even though the court ordered that they be returned so that they could be interviewed.
Well, at the time she left, she was not in Massachusetts. she had left Massachusetts. She was in New York. She did not know about the filing of the care and protection petition. She was not aware of that.
If new proceedings were brought, would they necessarily involve the same issues as in this case?
I feel very confident that, yes, that would be the case.
So
It would be
so the relief that we would give is the following, is what? That the department should not have done this, and therefore the department is barred from ever bringing a proceeding against your client?
Well, that I believe that 119 requires the identification of children before any even ex parte action can happen, so that if the children are brought before the court, before there's a removal, then that's an insurance that a parent would not leave the state without the knowledge that they do not have custody of the children.
But what if this identification requirement delays the proceedings?
Well, it would not, because
Well, here has it here?
it has here. It has here, but I believe that the court could have very easily and probably more correctly ordered precepts of the children immediately. And that would have allowed not only the Department of Social Services the Department of Social Services with the assistance of the police to go out and find the children and bring them before the court. And once the children were before the court, then there could have been an ex parte removal. But to have removed the children before identification of the children, it paved the way for criminal kidnapping
Is there a
charges.
statutory basis that you say not even an ex parte temporary granting of custody to the department, as was done here? Is there a statutory basis for the identification at that point before any action can be taken?
I believe the statute states before that
Isn't
there
that
must
the care
be,
and protection, isn't it? Connected
Pardon?
to the care and protection proceeding?
Yes, that there must be identification before hearing on the merits. I would interpret that hearing on the merits to be any adjudication of unfitness, which is what the court did by the
That's
ex
not-
parte removal.
That's not an adjudication of unfitness.
Well, there is, the court did find the mother unfit to remove custody from her.
Ms. Hanley, forgive me, I'm just looking at the relief that you've asked us. So leaving aside the mootness, I'm trying to see what relief is either appropriate or that we could do. And what you ask us to conclude is that the evidence presented, and that will be in the ex parte hearing. I mean, to which evidence are you referring? Evidence presented does not support DSS's conclusions that the children are in need of care and protection.
That would be the one affidavit dated January 16th that was submitted to the court, that was insufficient.
But that affidavit, as I recall, goes primarily to the removal of the children from the Commonwealth, correct?
Removal of the children from the custody of their mother and father. That was what the court used to, that was what the department used to get their, to obtain custody.
That triggered the 72-hour requirement,
That
correct?
should have triggered, yes.
Except that the children couldn't be identified for that because they were taken out of the Commonwealth and then the country.
Exactly, and my point is that there should not have been the ex parte removal if there wasn't a constitutionally guaranteed 72-hour hearing to follow.
But there was no hearing to follow because you took the children who therefore could not meet with counsel and be represented at the hearing. I mean, there was no hearing because your client prevented the children from meeting with their attorney and therefore having the opportunity for a hearing.
There's many occasions when when counsel doesn't have the opportunity to meet with the child. And in this case, this child was 3 years old. Counsel would have had to have used a substituted judgment. Yes, it is the best case to always meet with the child client, but there are often opportunities where we're not able to do, when counsel is not able to do that. And there is guidance on how to proceed when you can't meet with your child.
Ms. Hanley, your
client.
alternative request for relief is to order the court to conduct a 72-hour hearing. Now, is there a statutory impediment to that?
I'm sorry.
Is there a statutory impediment? I mean, we're now years later, correct?
Well, I believe that it would not conform with the 72-hour requirement of the statute, but would conform with the requirement for a temporary custody hearing to give the parents the relief, and the children the relief of seeking redress from the court on the issue of the removal.
You still have 2 minutes.
Okay.
You can forego them, believe me.
I would also like to mention that the department also failed to properly investigate this matter. In extreme cases of abuse, the department may defer immediately to the district attorney's office. In this case, they found that there wasn't that emergency requirement, but yet they failed to complete their 51B in a timely manner and just deferred to the same interview and the district attorney's office for further investigation.
I'm sorry, just going back a moment. Is it your position that there can never be an ex parte order unless and until the parent presents the children before the court?
Well, the parent doesn't always have to present the children to the court. It often occurs that on the petition, when the petitioner files their complaint, that the children aren't available. They may be in school, they may be in hiding.
But you're saying until the child appears before the court is not authorized to issue an ex parte order. That's your position?
The court could authorize and should authorize, the more appropriate remedy would be to authorize a precept to go out and get the children for the police, just what they did in this case. The Department of Social Services engaged the New York police. They engaged the New York Social Services. All that can happen, but the actual removal of legal custody of the children should not occur until the children have been
Okay, so let's
identified.
assume that a precept is done and the children are effectively arrested and brought in. Then the order can issue?
Then the order can issue.
Now, in this case, something strange happened. There was it looks like there was an agreement between DSS and the parents that they would let the kids stay in the home, provided the father left the home and certain testing was going to take place.
Yes.
Does that happen frequently?
I believe it does happen at the discretion of the department.
And that's why they didn't bring the children before the court, and the court could have placed temporary custody with the parents.
No, they didn't bring the children because the mother never knew there was going to be a care and protection
Well, why
file.
didn't DSS bring the children before the court? I guess I have to ask them.
They could have. They had the authority under 51B3 to remove the children that night. The department, in their discretion, chose to have father sign an agreement where he agreed to remain out of the home.
But if they had
And-
brought the children before the court on January 11th, 2008, we wouldn't be here today.
Well, the mother, I believe that the department filed it because they knew mother had left the jurisdiction. Mother had no idea that they were going to file a petition that day or any other day. She is of Russian descent. She doesn't understand how these matters work. She did what she thought she needed to do to protect her children. She grew up in communist Russia. She was very fearful of what happened that night, and I do not believe that she was trying to evade any legal authority here.
Ms. Hanley, just one other thing. What do I do with the judge's finding? He makes it as a finding that the department made reasonable efforts, but based upon the emergency nature of the allegations, reasonable efforts could not have prevented the need to remove the children, and ordered the temporary custody of the children to the department.
Well, we don't know. That ex parte hearing on January 11th was unrecorded. It was an unsigned affidavit. It was unrecorded. I understand that there was no attorney for the department present at that hearing. I don't think the affidavit of the social worker lays out what they did to prevent removal. And I think that in many respects, the judge's findings of fact differ significantly from what was in the transcript. He did make statements, make findings in the findings that were somewhat different from numerous statements that he made on the record.
Thank you, Ms. Hanley.
Thank you.
Good morning, Mr. Curhan.
Morning. May it please the Court, Dana Curhan for the father. I don't want to repeat the arguments we've just heard. What I do want to focus on is what happened with the father at the hearing.
On the January 16th hearing?
Actually, at the February 1st hearing,
okay.
he was not present there. The judge said, well, he really doesn't have to be present His counsel is here. It's a civil case. He can appear without his counsel. But I do have a real problem with the children not being here. Counsel, in essence, said, look, father doesn't have the ability to produce the children. They are with the mother. They are out of the country. He simply is unable to do that. The judge never actually went forward with the hearing, but at the time of the hearing, in essence, what he was saying is that because the children aren't here, I'm not going forward. In his
The judge was saying.
Judge was saying that.
Okay.
In his written decision, what he said was, I'm holding it against him that he didn't produce the children, but what I'm really holding is that there's a waiver. By not appearing at the hearing, he waived his right to contest that issue, and that therefore there's no right to a 72-hour hearing, and that's really what we challenge. I think
He was there. He was there by
he
through
was
counsel.
there by counsel.
But wasn't it that, I thought it was more the waiver was premised not so much on that he wasn't physically there, but he had been ordered to produce the children and hadn't done that.
Well, I think that's what that was one aspect, and I think that's why the judge held it against him that the children weren't
And
there.
it wasn't just that he wasn't there, that's all I'm saying.
Right. I think it was that he wasn't there. I think primarily it was because he wasn't there. Again, what the judge said in his order was, I hold it against both parents that the children aren't here,
Yeah.
and I find that the father has waived his right to a hearing. I'm just paraphrasing,
But he said that the mother did not waive her right to a 72-hour hearing.
I think he
Right,
I think
that's
he
right.
did say that.
So paragraph 11 of the judge's findings, that your client, quote, has refused to produce the children. When I read it, struck me as a little odd because there was an agreement that the father be out of the house immediately, correct?
Yes.
So he's out of the house.
That's right.
So the mother technically has physical custody at that point.
That's right. And
Was there any evidence that the parents were in communication with each other, colluding to keep the children out of state?
that was probably the position of DSS, but I don't think there was any evidence to that effect. And the representations...
But I don't care about positions. Was there evidence?
I don't believe there was. And
Whether there was or there wasn't.
well,
I mean,
I
there's
contend
no-
that there wasn't. I
Okay.
contend that there wasn't. And if DSS can point to anything, they can prove me wrong, but I contend that there wasn't. And I think it was pointed out to the court that he had no ability to produce the children. And that is simply my position.
Now, is it your view that the hearing should have gone forward without the children's attorney having had a chance to speak with them?
Well, I'm not sure. I mean, if it hadn't gone forward, it's quite possible that it may have gone forward at some other time. What I'm objecting to is that, not that it did or didn't go forward, but that the judge said it is not going to go forward because the father waived his right to this hearing. Unless there are any further questions, I'll rest on the brief.
Thank you, Mr. Cohen. Ms. Murphy?
Yes, good morning. May it please the Court. Lynn Murphy, representing the Department of Children and Families. I'd like to begin by pointing out that this case...
Do you have a position on whether this case is moot?
That's exactly what I was going to address, Your Honor, and it is moot for a number of reasons.
It is moot, but it is problematic if the children want to come back into the Commonwealth, isn't it?
No, it is not.
Because?
And that's another piece of the mootness issue.
Okay, that's the piece that I'm most interested in.
That, the CMP, as counsel has told you, has been dismissed 6 months ago. The department cannot relitigate that care and protection matter. That is gone.
It's dismissed with prejudice?
It's not dismissed. It wasn't dismissed with prejudice, but it might as well have been, because we cannot go in and relitigate the dismissed
You
care and
can't raise
protection.
you can't raise any of the facts in a subsequent proceeding?
No, we would have.
What's
We
the-
could.
help me understand that.
What would happen? What would happen in the worst case scenario? These people return to the Commonwealth, and there's new evidence of abuse and neglect.
No. What's the legal basis for saying that it cannot be reopened or that the evidence cannot be used at a subsequent proceeding?
Once it's dismissed, I don't.
But
believe
no,
you
no.
can-
But if it's not with prejudice, right?
Well, it cannot-
Why can't you, as soon as the mother comes back with the children, are all the children at issue now?
Are all the children
all the children are subject to this order.
Yes, they are.
Okay, so she comes back, there are 3 children, correct?
Right.
And she comes back, and the department, has reason to believe that there's a problem,
Based on new evidence,
based on new evidence.
sir, yes,
And they bring a petition.
true.
And you're saying they cannot introduce in evidence any of the facts that underlie the case that's before us?
As a background only.
I don't understand what as a background only.
Because what would happen is we would have to go in and say, here is the evidence, the judge would require current evidence of
Is it
abuse or
because
neglect.
it's stale? In other words, the evidence is
Yes,
stale and it
absolutely.
wouldn't support a current finding of
Absolutely.
unfitness?
Absolutely.
So
But
it might be referred to, but I take it at that point, since it's never really been adjudicated at all, it could be then adjudicated, if you got there as background. But it could never be the cause of a new petition.
That's exactly correct. I mean,
Nor the facts to support the granting of a new petition.
Right. The trial court would never act on such a petition. In fact, the record is clear that it was dismissed. And as we heard today, the criminal matters are also dismissed against parents. So if
You're
they-
saying those can't be reopened either?
the criminal?
Yeah.
Well, they could, but now there's no order, the custody order, the underlying element of the crime for kidnapping has been removed completely. So without another order,
But it was in existence at the time that the children were removed.
the order was, I'm sorry, I'm not following you?
The order was in existence at the time the children were removed.
That's correct.
Isn't that the basis of the kidnapping?
But that has been resolved. So
But-
now, in order for the kidnapping to be, I can't speak for the DA's office, but if, I would think they'd have difficulty. It's a higher standard of proof than we have in the care and protection matters. And I think they'd have a very difficult time coming forward and trying to reinstitute a kidnapping charge based on a order that has been dismissed for 7 or 8 months now.
Ms. I take the representation that you're making to the court, and I understand the standard is current unfitness, correct? It's not entirely clear to me, when we're dealing with children, that horrific events that occurred slightly over a year ago, would not support a current unfitness. You're saying
No, we need current evidence of parental unfitness. Again, these,
and what's the authority for that?
well, care and protection of Robert
Okay.
goes into, in quite detail, the statutory scheme of ex parte removal is absolutely appropriate.
No, I'm not talking about ex parte removals. I'm talking about, they're now
Right.
back in, the department receives notification. I mean, I'll have to look at care and protection of Robert, but it seems to
What
me...
I'm just trying to say is care and protection of Robert definitely goes in detail.
So if you have say a 12-year-old child, and there's a 51A report that child was abused by a parent 5 years ago, you could not conduct an investigation and try to substantiate that because the event was 5 years old?
Correct. That would be very, why, you're envisioning the department would revive a 5-year-old 51A and B for further investigation?
How about this
That would
set
be-
of... You have strongly supported evidence. There hasn't been a hearing, there hasn't been a determination that there's been gross abuse of a child, dehydration, starvation, sexual abuse, you name it. But the father disappears. The father is now back, but there's no evidence at the time that he is currently engaged in any of these acts. You're saying that the department cannot bring that old 51A report.
Well, it would depend what happened at the trial court level. Those facts are very different from the facts that we have in this case. But certainly if there was, as Your Honor stated, gross and
Sure. In the past, and
abuse
then
and
for
neglect,
whatever reason...
that would be very unlikely that the trial court would dismiss that petition. And we would, certainly the department would aggressively argue that it not be dismissed. And maybe continued efforts would be made as
To find the father.
Exactly. But this case, unfortunately, has a number of procedural defects due to the fact of the unusual situation where we have with the parents disobeying court orders, deciding to leave the country, having an ability to stay in another country.
I recognize that, and that's why I'm a little I'm just probing as to whether the department really would stand back and say, we're going to do nothing.
No, no, what would happen and what could have happened even a little earlier, maybe in this case, as you know, the department sought to continue with the 72-hour hearing and prove its burden, meet its burden. The delays, certain amount of delay, pardon me, to remedy procedural defects is certainly understandable, and that's what the judge tried to accomplish here. But after a certain amount of time has passed, the department must proceed to meet its burden of proof or not meet it. So in the situation that you raised, the department would have to meet its burden, and it sounds like we would be able to, given
And
the
that,
facts.
in my hypothetical.
In your hypothetical,
Yeah.
exactly. So at that point, we would not hopefully see a dismissal of the CMP. But in this case, that has not been the case.
Now, in this case, on January 11th, 2008, the first day, two social workers and two police officers went to the family home to investigate the Section 51A report. And the father said that he wanted to videotape the interview with his own camera, his own video camera. And the social worker said, no, we're not going to do it that way. And then they worked out some kind of an agreement. Did the social workers have the authority at that point to take the children into court and have them identified?
I don't believe so.
Is that because they couldn't substantiate the Section 51A?
Well, what would have to happen is the department...
No, my question is it because the Section 51A had not been substantiated?
No, that is not. We do not need to substantiate the 51A because the 51B investigation would take at least 10 days, sometimes longer. So that is not a part of requesting custody. But we need to go in and have a threshold determination of reasonable cause to believe a suspicion of abuse and neglect, which was done through our social worker appearing in court and filing an affidavit explaining the circumstances of the case. It's not hinged on the completion of the report.
So what was the earliest point in time that the social workers could have removed the children and brought them to court for purposes of identification?
Well, they moved pretty quickly. I think at the department, and this is part of the statutory scheme as well, we have to make reasonable efforts to keep a family together before we just rush to
Yeah, but my question is,
remove.
when was the earliest time they could have done
I
that?
can't imagine they would have gone much earlier because they wanted to work with the family. And they did have trouble with cooperation, clearly, but I think the social worker was hoping, and the department certainly was hoping, that the parents would allow the SANE interview to go forward. And at that point...
So if parents refuse to allow a SANE interview to go forward,
They did.
the department cannot go to take the children and bring them into court and have them identified?
I don't see how they can. We don't have custody at that point. We need to get the custody ordered to remove the children. The parents have custody. We can't act. There's no authority to allow us to remove.
Okay, so you're saying that you can't take custody until you get an ex parte order,
That is correct.
and Miss Hanley is saying you can't get an ex parte order until you deliver the children.
Oh, yeah, I realize, but I disagree with, again, I think the statutory scheme is clear. The department can go in an ex parte or not, depending if it's an emergency. We get the order. The order allows us to get the precept, which is the mechanism to bring the children to the court for identification, and the identification should happen before trial on the merits.
And that's the procedure that's typically followed.
Yes, yes. And again, because of the unusual nature of this case, this was not able to be followed.
Miss Murphy, how old are these children now, today?
I believe the youngest is 4 years old, and I believe the oldest would be around 8 years old.
And they all living together, as far as you know, with the mother?
That was my last understanding, that the mother and the 3 children still remain in Russia, but I have no, outside this record, I have no knowledge of the current location. Well, if there's no other questions.
Thank you, Miss Murphy.
Thank you very much.
Good morning, Mr. Cohen.
Good morning. May it please the Court, Andrew Cohen on behalf of the children. I just wanted to quickly answer Justice Gant's question about whether the department can take the children without going to court. Yes, under Chapter 119, Section 51B3, that's the at that time operative section of the statute, the department can take custody before going to court. It then must go to court the next business day.
So in your opinion, what was the earliest time the department could have taken custody of the children?
It could have taken custody of the children as soon as the 51A was filed.
Mr.
But
Cohen,
that would
you've been
depend on-
through this thicket many times, so maybe you can help me out. I have from Ms. Murphy a representation that the case is closed. The mother comes back into the Commonwealth with or without the children, and it's closed until there's some new triggering event. And yet, so I'm just looking at your relief. You've asked us to affirm the order of the juvenile court deferring the 72-hour hearing until mother presents herself and waiving the father's right to a 72-hour hearing. As a practical matter, what difference does that make to your clients?
At this point, Your Honor, none. The case is gone in the juvenile court. There is no remand relief.
So, protecting your clients, the children's interests, if we were to conclude that the case is moot, your clients are no worse off than if we were to go to the merits, or you can do it either way. I mean, mootness, you don't need us to reach the conclusion that you've asked us. You don't need us to enter the relief that you've asked us to enter.
That's right. At this point, there is nothing for the juvenile court to do. My clients are in the same position they would be in otherwise. That's right.
Do you know what, if any, impact a ruling on the merits or a failure to rule on the merits would have on the immigration consequences? Is the mother or the father a resident alien or a citizen of the United States?
It's my understanding from the record that the mother and the children have dual citizenship, so I don't believe there would be immigration consequences. I'm not aware of the father's citizenship status. I believe he's just an American citizen. I did want to get back to your question, Chief Justice Marshall, about whether or not the facts brought, the allegations brought in this case might come back to haunt the family should the case be refiled. I think that, yes, all facts are fair game. There is no such thing as stale facts as a practical matter in terms of what can be alleged by the department. In the usual case, these affidavits are filed by the social workers, and they recite an entire history of the family. So these facts could very well come back to be put in play one way or the other.
But there's been no adjudication of the facts, correct? So, I mean,
That's
they would be, like any other fact, it would have to be proved.
That's right. They'd simply be older allegations.
Well, the fact that she removed, I mean, proof would not be difficult. So her failure to comply with court orders, there's no question the mother hasn't claimed that the court did not have jurisdiction over her, I don't think, has she?
That's right. There's been no claim of that.
So the court had jurisdiction over her, and she did not obey court orders.
That's right, and that would be one more allegation that the department would theoretically be able to bring should the department choose to refile the case. And as you indicated, the case has been dismissed without prejudice, and so all facts are fair game should the department choose to refile. Despite the many twists and turns of this case and the fairly extraordinary circumstances, from the children's perspective, again, the children have no position on the merits of this case. From the children's perspective, this case is really only about the right to counsel and about the importance of having meaningful counsel at a 72-hour hearing. The juvenile court gave many reasons why the 72-hour hearing shouldn't go forward, but the only one it needed was one of the reasons that it cited, which was that the children didn't have the ability to meet with their counsel, so they had no meaningful right to counsel.
That presupposes that counsel always must meet with the children?
Yes, and I want to disagree with some of the statements earlier. In order to represent your clients at any important due process hearing, you have to meet with them. You have to learn what their expressed preferences are. You have to observe them in the context of their current living situation in order to determine what position you're going to take. I think as a practical matter, there may in fact be cases where children's lawyers do not see their clients before the 72-hour hearing. That is not what Rule 1.14 of the Rules of Professional Conduct or the CPCS performance standards instruct attorneys to do. The CPCS performance standards are very clear that children's lawyers must see their clients as soon as they're appointed and must do so before the 72-hour hearing. precisely for this reason.
Had counsel been appointed in this case?
Yes, in this
Before the hearing? Counsel for the children?
Yes, counsel.
Okay.
The petition was filed at 3 o'clock
Right.
on the 16th. Counsel was appointed at 10 o'clock the next morning by fax. The trial lawyer did a very thorough, diligent job trying to reach the children, trying to get information about the children, and despite her best efforts, was unable to meet with them. And it's important to keep in mind that everyone believed that this was only a temporary situation. There had been representations made in court that the children would in fact be produced. And so nobody knew until about a week after the petition was filed that in fact the children were out of the country and were unlikely to be brought back to meet their counsel. But Children's Trial Counsel was very diligent.
So on January the 16th, when counsel for the children had not been able to confer with their client, what should the judge have done?
The judge was just appointing on that day, right?
That's right. The judge appointed counsel on that day. But when the judge became aware that Children's Counsel, through no fault of her own and despite her diligent efforts, was unable to reach the children, the judge should have done exactly what the judge did in this case, which is to say, we cannot have a 72-hour hearing until you have a chance to meet with your clients. And in fact, that's what usually happens. In most courts, judges will wait until the afternoon session, or they'll give a day or two so that children's attorneys can go out and meet with their clients. And again, precisely for this reason.
Thank you, Mr. Cohen.
Thank you very much.